if you're dividing a military retirement, there are certain misconceptions that people have. One of which is that they're automatically entitled to a share of a military retirement if they've been married 10 years or they've been married 20 years. As a retired military JAG, I can tell you that's not the case. In Colorado, in order to divide a military retirement, it must be divided by the court. The common misconception that people have that somehow there's an entitlement to a military retirement after 10 years usually comes from the fact that if you've been married to a military member for 10 years, overlapping 10 years of military service, and the court awards you a portion of the military retirement, Department of Defense will pay you directly. The Defense Finance and Accounting Service, or DFAS as most military families know them, will send a check to that spouse when the military retirement is being paid out. That may be where the 10-year misconception comes from. The 20-year misconception comes from the fact that at 20 years, that overlap 20 years of military service, a spouse is entitled to keep their ID card and they retain their health care benefits and they retain certain other benefits. And that's often where the misconception is that at 20 years you're entitled to a portion of military retirement. It's simply not true. Under federal law, the courts are allowed to divide military retirement, but it's state law that determines how and what percentage you'll get. In Colorado, the way we generally divide military retirement is the spouse gets what we call a marital share. And a marital share is determined by the number of months that they were married to the military member during the military member's service. And that sounds complicated, but the division really isn't that difficult. For example, if it was a 20-year marriage and the unlikely event was that the spouses were married the day the member entered the military and they were divorced the day the member retired from the military, that would be precisely 20 years. So 1/2 of that military retirement would generally be awarded to the non-military spouse. But if you were married for 10 years to that spouse and they did a 20-year career, you may be entitled to around 1/4 of the military retirement. So it's, well, not a complicated process. To get the language right and to get the language right in the court documents is a fairly complex procedure, and I would advise folks to talk to an attorney about it. It's one of the areas that I spend a good deal of time working with my clients on to make sure that the calculation is right. If you're the military member, we don't want you to have to pay any more than you should. And if you're the non-military spouse, obviously when I'm working with them, we're trying to maximize the return to them to make sure they get what they have earned during the course of the marriage.